Unit 2, Plagiarism and Its Implications. Welcome to MyDan GST Noun, your one-stop channel for mastering GST and building real knowledge that works. Whether you're a NOUN student, from another university, a lecturer, or just someone hungry to learn, this is for you. Make to subscribe. This material is from National Open University of Nigeria. My name is Dan Asukwo. Introduction. This unit will be discussing copyright infringement in details to enable you understand and avoid such infringements. One of such infringements is plagiarism, which will be highlighted in this unit. Also, the similarities and differences between copyright and plagiarism were discussed. Intended learning outcomes. By the end of this unit, you will be able to explain the concept of infringement and plagiarism, demonstrate the skills in applying copyright and plagiarism laws in writing academic papers. Main content. Copyright infringement. Copyright infringement is any infringement upon the rights of a copyright holder. Copyright law gives a copyright holder, usually the creator of the work, a set of rights that they and they alone can exploit legally, save for exceptions such as fair use. Those rights include the right to reproduce, copy, a work, the right to create derivative works based upon it, the right to distribute copies of the work to the public, the right to publicly display or perform the work. There could be a wide variety of activities that are copyright infringing, including performing a copyrighted play without permission, writing an unauthorized sequel to a work, or simply making copies of the work. In short, copyright infringement is a very broad term, rooted in the law, which covers a wide range of unlawful activities that violate the rights, granted by the law, to copyright holders. Copyright infringement. Plagiarism. Copyright infringement is a construct of the law, while plagiarism is a construct of ethics. Plagiarism is defined as the taking of the original work or works of another and presenting it as your own. The word work here can include a variety of things such as ideas, words, images, etc. Anything that is seen as an unethical and unattributed use of another's original creation can be defined as plagiarism. The similarities between copyright and plagiarism. Plagiarism and copyright have a lot in common. Works that can be plagiarized could be copyrighted. Plagiarism deals with creative or academic works, and these types of works, typically, qualify for copyright protection when they are new. In fact, many plagiarisms are copyright infringements. Here are some examples of plagiarism that are also copyright infringements. Plagiarizing a blog post on a new site, copying an encyclopedia article without attribution for a book and reporting, or submitting a photograph someone else took under your name to a magazine, etc. As such, many cases of plagiarisms are addressed through the legal framework provided by copyright law. Plagiarized contents posted online are often removed with takedown notices. Commercial plagiarisms, for example in advertisements, are often dealt with through lawsuits and so forth. However, not all plagiarisms are copyright infringements, and not all copyright infringements are plagiarisms. Although there are many similarities between them, yet they differ in some ways. Differences between copyright and plagiarism. The key difference between plagiarism and copyright infringement is that not all plagiarisms are infringements, and not all infringements are plagiarisms. For example, a person can plagiarize almost anything, including works that are not protected by copyright. Works that are in public domain can be plagiarized, but because they are not protected by law, they cannot be copyright infringement on them. Also, plagiarism often covers things that are not covered by copyright. Ideas, facts, and general plot elements are all things that can be plagiarized, at least in certain situations, but generally don't qualify for copyright protection. It's also worth noting that one might get permission to use a work and still plagiarize. For example, one may get permission to submit a purchased essay, which means that the use is not an infringement, but it is still a plagiarism as the work is not originally yours. To make matters more confusing, most copyright infringements don't really hinge on whether a use is attributed to its original owner. For example, if you passed out copies of a play without permission, it's most likely an infringement whether you tried to take credit for it. Attribution generally doesn't make an infringing action legal. Self-assessment exercises. Plagiarism is defined as. Let's have your feedback on the comment section. Conclusion. All forms of plagiarism should be avoided. It doesn't cost anything to acknowledge ideas and works used in the course of research. Protect your reputation and that of your institution by ensuring that you do not morally or legally infringe on authors' rights. To recap what you have learned in this unit, let's have your thought on the comment section. Subscribe, and don't forget to share with your friends, classmates, and academic groups. Together, let's make learning simple, fun, and rewarding.